All right, I will call the Senate Judiciary to order and ask the Secretary to please take the roll.
Senator Harris, Senator Dondera Loop, Senator Orenshaw, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you so much. We have everybody present, which means it is an ideal time to get into our work session. We have a number of bills on work session today. We are going to take 4 of them on a consent calendar, which means it'll just be one vote for the 4 bills. Those are AB 32, AB 275, AB 291, and AB 350. So we'll start with the consent calendar, and then we will go to AB 76 and the rest of them, AB 51, 55, 272 and 405 in numerical order. I will turn it over to Mr. Guinan to go through the work session document on the consent calendar first.
Excuse me. Thanks, Chair. Pat Guinan for the record. As the Chair mentioned, we're starting off with the consent calendar. The first bill is AB 32, which is an Assembly Judiciary Committee bill on behalf of the Department of Sentencing Policy that we heard on May 1st. There's a lengthy summary here of the bill, Chair. I don't go through it all unless you want me to. AB 32 generally revises provisions governing the Department of Sentencing Policy, including changing the requirements to serve as the executive director and addressing confidentiality of certain records and requiring the collection and reporting of data on the length of imprisonment and recidivism rates for persons whose probation, suspension of sentence, or parole supervision is revoked due to technical violations. It also makes changes regarding the division of parole and probation that are similar and revises risk and needs assessments administered to certain probationers and parolees. And finally, it authorizes the State Board of Parole Commissioners to revoke probation or suspension of sentence or parole supervision at the request of a probationer or parolee. That's all I'll go through right now, Chair, unless you want to have more information.
That was very helpful. Thank you. Remember, we're doing the motion as a consent calendar, but are there any questions on this particular bill, AB 32? All right, then we'll move on to the next one.
Okay, thanks, Chair. The next bill is AB 275, which is sponsored by Assemblywoman Hardy and others. We heard it here on May 11th. AB 275 prohibits a court or agency of criminal justice in this state from charging any fee related to the sealing of a criminal record if at the time the crime for which the record to be sealed was committed, the petitioner was being sex trafficked, and the petitioner is required to include a statement in the petition certifying that at the time the crime was committed they were being sex trafficked. That's all I have on AB 275.
Any questions on AB 275? All right, on to the next.
Okay, thanks. The next is Assembly Bill 291. It's an Assembly Judiciary Committee bill. We heard it here on the 20th of April. It provides that the state is not required to establish that all the acts constituting a crime of swindling occurred in this state or within a single city, county, or local jurisdiction of this state. And it further provides that it's no defense that a person did not commit all the acts constituting the crime within this state or in a single city, county, or local jurisdiction of the state.
Any questions on AB 291? All right.
Okay, thanks. And the last bill on the consent calendar is AB 350. This regards forfeiture of property. It's an Assembly Judiciary Committee bill, which we heard here on the 17th of April. It requires each law enforcement agency to include additional information relating to seizures and forfeitures in the annual report submitted to the Office of the Attorney General. And it additionally requires the Office of the Attorney General to make the reports relating to seizures and forfeitures that are published on this internet website available in machine-readable format.
I just want to clarify, I think this is the bill we heard yesterday.
Oh, I'm sorry, the wrong date. Yes, I believe
Okay.
you're right.
That being the case, any questions? All right, then I would accept a motion to do pass the 4 bills on the consent calendar.
So moved. Second.
All right, we have a motion from Vice Chair Harris, a second from Senator Stone. Any discussion on the motion? I don't see any discussion, so all in favor, aye. Aye. Any opposed, nay. It is a unanimous vote to pass the 4 bills on the consent calendar. I will assign the floor statement for AB 32 to the first volunteer. Nope. Senator Stone, it's yours. I will assign the floor statement on AB 275 to Senator Krasner. I will assign the floor statement on AB 291 to Senator Orenshaw. And the statement on AB 350 to Senator Hansen. And that takes us to AB 76.
Thanks, Chair. Pat Guyan again. This is AB 76. We heard it here on May 8th. This is a bill sponsored by Speaker Yeager. AB 76 increases from $1,500 to $15,000 the maximum amount of costs that a court may award to a prevailing party for the reasonable fees of an expert witness.
Any questions on AB 76? Senator Hansen.
My only concern was 1,500 to 15,000 is a heck of a big jump, and I'm just wondering if anybody had done like an inflation calculation or anything like that. I mean, I don't have any problems with, the law as currently written allows a judge a great deal of discretion, it sounded like anyway. So I don't know if it's really worth worrying about, but it just seemed like a heck of a big jump from 1,500 to 15,000 in one fell swoop. I have no idea when the last time that number was adjusted. Was it $1,500 from 1958 or something? I have no idea. So anybody got any ideas on that?
I think there was some testimony on this. I don't know if maybe legal could weigh in on when the $1,500 was set.
Carly O'Krent for the record. I can look that up and get back to you. I don't have it in front of me right now.
I don't know.
Okay.
Honestly, it's not that big a deal. I mean,
Okay.
I'm going to support the bill. I'm just more curious about. I always hate seeing numbers jump that much in statute like that. So anyway, not worth worrying about. If she could get me that number just out of curiosity, and then if I do have concerns, I can change my vote on the floor.
I think that makes perfect sense. I would also encourage you to ask the sponsor if he has some of those statistics about, average costs and things like that. I think he probably would.
Will do. Thank you, Madam Chair.
Senator Stone.
Thank you, Madam Chair. I do remember the discussion. I do remember the testimony when the speaker was giving the testimony, and it hasn't been adjusted for years. And had they put a CPI increase on it, it would have been much higher than the $15,000. It was like $30,000, and so he kind of still cut it in half because it was such a big jump. But that kind of refreshes my memory on what he testified to.
Thank you. I think that's helpful. Any other questions on AB 76? Not seeing any, I would accept a motion to do pass. We have a motion from Senator Krasner, a second from Senator Wynn. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. It's a unanimous motion to pass Assembly Bill 76, and I will assign the floor statement to the first volunteer. Nope. Oh, okay. Senator Harris. And that takes us to another bill, and Patrick is going to tell us which one.
Thanks, Chair. Patrick Guyan again for the record. We're at Assembly Bill 51 now. This is an Assembly Judiciary Committee bill on behalf of the Attorney General that we heard here on April 20th. And I'll go through the whole thing. It revises the period for the mandatory and discretionary arrest of a person suspected of committing a battery which constitutes domestic violence. The bill requires a peace officer to arrest a person suspected of such a crime if the peace officer encounters the person while responding to the initial request for assistance relating to the battery within 24 hours after the alleged battery, or if the peace officer did not encounter the person while responding to the initial request within 7 days after the alleged battery. The bill prohibits a court from granting probation to or suspending the sentence of a person who is charged with committing a battery which constitutes domestic violence that is punishable as a felony. There are two amendments proposed to the bill. The first is from the Attorney General, and it is attached for your review. It adds language defining what constitutes quote-unquote relevant training for a victim's advocate who provides services to victims of domestic violence, sexual assault, or human trafficking. The second amendment is from the District Attorneys Association, which was discussed at the hearing as well. It revises language concerning a peace officer's quote-unquote direct interaction with a person who's alleged or suspected to have committed battery, and to arrest and the arrest of such a person. That's all, Chair.
All right. Any questions on AB 51? Not seeing any questions, I would accept a motion to amend with both amendments and do pass. There is a motion from Senator Wynn to amend, and do pass, and a second from Vice Chair Harris. Any discussion on the motion? Sure. Senator Orenshaw.
Thank you, Chair. I'm going to vote yes today. I just want to reserve my right. There's still a few questions I have on this one and with the amendments. Thank you.
Absolutely. All right. Not seeing any other discussion. All those in favor, aye. Aye. Any opposed, nay. It is a unanimous vote. Amend, and do pass AB 51. Floor statement will go to Senator Don Darrow Loop.
Thanks, Chair. The next bill is Assembly Bill 55, which is an Assembly Judiciary Committee bill on behalf of the State Treasurer. The bill revises provisions of the Uniform Unclaimed Property Act, including but not limited to changing the dates on which certain property is presumed abandoned, requiring the administrator of unclaimed property to create and maintain a statewide publicly available searchable database that includes the name of the person reported to be the apparent owner of the property. It removes the requirement that the administrator must provide written consent before the abandoned property is delivered to the apparent owner if the receipt of the property is in the best interest of the state, and it revises the notice that the administrator must make to sell certain abandoned property. It also authorizes the administrator to request a state or local agency to provide certain confidential information for the purpose of facilitating the return of unclaimed or abandoned property, and to adopt regulations relating to agreements which assist a property owner in the return of the property that is presumed abandoned. And finally, it repeals provisions requiring that the act must be applied and construed to effectuate its general purpose to make the law uniform among the states that enact the act. There is an amendment from the State Treasurer's Office that's attached for your review. It revises from the second renewal to the first renewal of a time deposit, the time at which such a property is presumed abandoned, and it provides for the annual publication of a notice concerning abandoned property in a newspaper of general circulation in a county whose population is less than 700,000, and it sets forth criteria for the contents of such a notice, and that's all.
All right, any questions on AB 55? Not seeing any questions, I would entertain a motion to amend and do pass. All right, we have a motion from Senator Stone, I think, and a second from Senator Orenshaw. Any discussion on the motion? Yes, Senator Krasner.
Thank you, Chair. I spoke with Treasurer Zach Conine after our meeting, and I asked him to change. He was proposing to change the publication from 6 times per year to 0 times per year. I asked him if he would at least publish once per year, in addition to putting it on the website, because of my concern that some senior citizens might not see it otherwise because they don't have access to the internet. And he agreed, and I really appreciate that, and so I will be voting yes. Thank you.
All right, thank you. Any other discussion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. All right, a unanimous motion to amend and do pass AB 55. I will assign the floor statement to Senator Krasner.
Okay, Pat Guyan again for the record. We are now at Assembly Bill 272. This is sponsored by Assemblywoman Monroe Moreno. It deals with mail theft. It creates the crime of mail theft as a Category D felony. We heard the bill on May 11th. I won't go down the bullet point list here, Chair, unless you want me to. It sets out what constitutes the crime of mail theft. There is an amendment that the Nevada District Attorneys Association, in consultation with the sponsor, have proposed, and it's here for your review. It removes language referencing personal identifying information, and also the word breaks in relation to opening certain mailboxes. And that's all, Chair.
All right. Any questions on AB 272? All right. We have a motion from Senator Stone to do pass. Amend and do pass. Do we have a second? A second from Senator Krasner. Any discussion on the motion? Not seeing any. All those in favor, aye. Aye. Any opposed, nay. All right, the motion carries to amend and do pass AB 272, and I will assign the floor statement to Senator Stone.
Okay, last bill on the work session today is Assembly Bill 405, which revises provisions relating to court programs for the treatment of mental illness or intellectual disabilities. It's an Assembly Judiciary bill. We heard it on May 5th. The bill authorizes a justice court or municipal court to establish a program for the treatment of mental illness or intellectual disabilities, and to transfer original jurisdiction of a case involving an eligible defendant to the district court if the justice court or municipal court has not established such a program. And it further provides that the district court, justice court, or municipal court may impose sanctions against the defendant for the violation, but allow the defendant to remain in the program. There is an amendment submitted by Judge Wood, who presented the bill. It's attached for your review. And I just want to note for the members that the amendment that was submitted by Judge Wood is inserted into an amendment that was approved in the Assembly, so I don't want anybody to be confused, but the language of the amendment appears on page 4 of that document, and it seeks to clarify that a transfer of a case to a district court may occur if the Justice Court deems it appropriate and necessary and the district court approves it, regardless of whether the Justice Court has its own program. And secondly, it clarifies that a transfer may occur for both individuals who have already been adjudicated and individuals who are in a deferred prosecution, rather than being limited to only individuals who have already entered a plea. That's all, Chair.
Thank you so much. Any questions on AB 405? I don't see any questions, so I'd accept a motion to amend and do pass. All right, we have a motion from Senator Wynn, a second from Senator Dondero Loop. Any discussion on the motion? Not seeing any discussion. All those in favor, aye. Aye. Any opposed, nay. All right, motion carries unanimously to amend and do pass Assembly Bill 405, and I'll give the floor statement to Senator Wynn. And that brings us to the conclusion of our work session, which means it is time now for our bill hearings. We will start with SB 449, and I'll invite Mr. Reynolds up to give that presentation whenever you're ready. The bill hearing is now open.
Thank you, Senator Charles. Terry Reynolds, Director for the Department of Business and Industry. With me at the Sawyer Building is Cara Brown, our ALJ for the Consumer Affairs Unit, and also our Chief Investigator, Chris Williams, who has been with us actually for this program since the beginning. So legislation was passed requiring registration of structured settlement companies, and at the time we were asked whether we would mind being the entity to do the registration for these companies. There's approximately 22 companies that engage in structured settlements. At the time, when this was set up, we were also working to get the Consumer Affairs Unit under permit authorization. Since 2013, it was reauthorized every 2 years. So every legislative session, we had to go in and get the Consumer Affairs, as I say, re-upped to be able to have it be authorized under statute. At that time, and after the session, we were able to get that under a permanent section under 598, which is the fraud, deceitful practice area. And at that time, we thought that we could be able to do regulations and do fees for the regulation of these structured settlement companies under the general authorization of 598. We consulted with the LCB, and they felt that we should get specific authorization because of the nature of how the Consumer Affairs Unit was set up. So with that, that's how SB 449 came under being. So what does it do? It authorized the Consumer Affairs Unit to adopt regulations in consultation with the Director of Business and Industry to carry out the provisions of NRS 42.200 to 42.400 inclusive. It also authorizes the Consumer Affairs Unit to charge an initial and renewal registration application of $250, a late registration renewal of $375 upon failure to renew their registration within 60 days after the expiration, and a registration reinstatement fee of $500, which would allow registration if they allow it to lapse. If they do not register within the late fee time, they let everything lapse, then it's $500. It also allows surety bonds or a letter of credit instead of cash bonds. In 449, in the way it was originally set up, it allowed cash bonds. We would much prefer, and I think the state of the art is that people file letters of credit or a surety bond instead of cash bonds. So that's basically what it does for the legislation. Like I said, we had about 22 companies that we have registered in the past. We have not accepted any funds for that, but we would like to be able to set up a fee of $250 to do that. We did work with staff in terms of their time element to be able to work through the registration of these companies. Basically, we will be accepting applications, renewals, processing payment receipts, tracking company profile, including bonds and contact information, if needed, investigations and enforcement, and then issuing certificates that they are registered within the state of Nevada. So that's essentially what we will do with the legislation. We will promulgate regulations to be able to do that if this bill passes. Thank you.
All right, thank you. Any questions? Senator Stone.
Thank you, Madam Chair, and thank you for the presentation. Can you just compare and contrast for me the advantages and disadvantages of a cash bond versus a surety or a letter of credit when it comes to security and when it comes to the cost of the business to provide such security?
Well, cash bond is actual cash that they have to put up.
Yeah.
And a letter of credit is that they have money available within the bank. The bank issues, usually, or the financial institution issues a letter of credit. There is a cost to do that, but it's not like having to take cash out and dedicate that cash. You're able to basically collect interest on that money that's within the bank. A surety bond is where you go to a surety company
Right.
and you pay for that bond, which is much more cost effective than actually putting up the cash.
Okay, so from a state perspective, we really don't care, but from a business standpoint, it's probably less expensive for them to go for a surety or a letter of credit. And I assume that with a letter of credit, if their balances don't reflect a value of the letter of credit, that the bank must notify.
That is correct. Terry Reynolds, for the record, Director for the Department of Business and Industry. That is correct, and we feel that it's much easier for us to work with a financial institution with either a surety bond or a letter of credit than have to really account for cash and making sure that that cash bond stays whole within the period of time. So you are correct.
All right, any other questions? Not seeing any. Thank you so much for your presentation.
Thank you.
And we will move to testimony in support of SB 449. Anybody wishing to give support testimony is invited to do so up front. And we have somebody in person in Carson City. Please go ahead whenever you're ready.
Madam Chair, members of the committee, Alfredo Alonso, the law firm of Lewis and Roca, today representing the National Association of Settlement Purchasers. And when this body regulated the industry last session, I think we were all under the impression that the division had the authority to, in fact, charge a fee for this license. And so, unfortunately, we found out that was in question. So we're back before you, just letting everyone know that we had agreed then, we agreed now, that that needs to be fixed if possible. Thank you.
Thank you. I don't see anybody else coming up to give in-person testimony in Las Vegas or Carson City, so we'll go to the phones for in-person testimony in support of SB 449.
Thank you, Chair. If you would like to testify in support for SB 449, please press star 9 to take your place in the queue. We have no callers testifying in support at this time.
All right, then we'll go to testimony in opposition to SB 449. I don't see anybody coming up to give in-person testimony, so we'll go to the phones for opposition to SB 449.
If you'd like to testify in opposition to SB 449, please press star 9 to take your place in the queue. We have no callers testifying for opposition at this time.
All right, then we will go to neutral testimony on SB 449. I don't see anybody coming up to the table to give in-person testimony, so we'll go to the phones for neutral testimony on SB 449.
If you'd like to testify in neutral for SB 449, please press star 9 to take your place in the queue. We have no callers testifying in neutral at this time.
All right, then. Do you have any closing remarks?
Terry Reynolds, Director for the Department of business and industry. Just Chair Scheibel, just to thank you and members of the committee for allowing us to give testimony on this. And if there are any questions that come up, we'll be happy to answer them subsequently. Thank you.
All right, thank you so much. I will close the hearing on SB 449. All right, and I would accept a motion to do pass. We have a motion from Senator Orenshaw, a second from Senator Stone. I assume there are no questions on the bill since you just had the opportunity to ask them and didn't. Good job. Any discussion on the motion? All right, all in favor, aye. Aye. Any opposed, nay. All right, it is a unanimous vote of those senators present, which includes everybody except for Senator Wynn. And I will take the floor statement. And that brings us to our next bill hearing on AB 452. I will now open up the hearing on AB 452 and invite the presenters up to the front to go ahead and begin whenever you are ready.
Good afternoon, Madam Chairwoman and members of the Senate Judiciary Committee. For the record, I am Sabra Newby, Assemblyperson representing District 10 in Central Las Vegas. With me to present AB 452 is Ms. Jody Hawking of Return Strong and Director James Zarenda of the Nevada Department of Corrections. AB 452 represents one of the recommendations from the Joint Interim Standing Committee on Judiciary, which was to draft legislation requiring NDOC to adopt and publish a policy regarding prison visitation that includes, without limitation, a procedure for appealing a decision to deny a visitation request and prohibiting NDOC from banning in-person visits for approved visitors under certain circumstances. Unfortunately, the bill as written is overly prescriptive in its requirements, which threatens the full implementation of the bill. Work has been ongoing as late as 5 minutes ago with Ms. Hawking of Return Strong and Director Zarenda to come to a mutually agreeable position. And we did submit to you yesterday a conceptual amendment, which is still a work in progress. But I'll boil the bill down and the intent of the bill down to this. We wanted to ensure that there was in statute a guaranteed ability for visitation in prisons, and we wanted notice if those visitations were not going to be held. And we also were interested in maybe establishing an ombudsperson who would be able to be sort of a pressure reliever or a fixer of some sort for issues that may come up with respect to inmates. So I'd like to turn it over to Ms. Hawking and Director Zarenda for further discussion on the amendment and the ongoing work. Thank you.
Good afternoon. My name is Jody Hawking, Jodihockking, and I just want to thank the chair and all of you for hearing this bill. And Director Zarenda, really, we have put in an enormous amount of work in coming to a middle ground and something that I think is acceptable and will work for all parties involved. One of the things that I really feel like I've learned in the 2 years of doing this work is that there's two sides to every story. And it doesn't make one side 100% right and the other side 100% wrong. A lot of it depends on your perspective and the angle that you're looking at things from. For families, one of the voices of people and our loved ones that are in prison are so often silenced, and their experience is really hidden from public eye. I guess I started to realize this even as I was starting to talk to legislators, and I thought things that were like common knowledge for us or common experience were foreign to many of you. And so those experiences are often hidden. And really what we've been calling for all along is communication and transparency and really understanding and oversight. We have begun to make strides in that with the current administration. But unfortunately, prisons are really a space that are hidden from public eye. Unless you end up being touched by incarceration, which I hope none of you are, then the imprisonment of your loved one or yourself is something that's really difficult to comprehend all of the pieces that happen to it. Over the past couple of years, we have started to do a lot of like research and studying into really what are those principles behind what make good oversight. One of the things is that prisons really need layers of oversight. There's not one thing or one type of oversight that will fix every problem. And so this bill is an attempt to really find a way to fix as many as possible. I'm going to skip that part because it's long, so I'm going to just go to the next part. There are a few best practices through research and people who really are experts in this, and one of the key ones is that when you start to look at oversight, that it's independent from Department of Corrections, both in staffing and funding, that the oversight really focuses on two main areas, either investigation and or monitoring of prison conditions. And then the third thing is access to prisons, access to people that are impacted, records and data. And I think we've done a pretty good job of finding ways that this works in Nevada. There are states that are starting to implement oversight bills, but each one is really dependent on what is good in that state and what works in that state. And so that was what I feel like we tried to do here. So I'm gonna just kind of go through the bill. I think of it in two sections. The first section on visitation. So the first part really was just to codify the administrative regulation for visitation regarding in-person visitation. One of the concerns for families and incarcerated people, because we've seen this happen at county jails, we've seen it happen across the country, that as we start to move towards video visits, that many places then lose in-person visit. And we've talked a lot with tablets and everything else that, and have a commitment from the director that matters. And so where you see the levels, that is exactly what's currently in policy. We just wanted to make that statute so that there's some protection going forward to make sure that visitation couldn't be taken away as video visits were implemented. The second part of the visitation bill is around cancellations, and that has come out of the past few years as visitation came back after COVID. The severe staffing shortages has created a monstrosity as far as visitation and cancellations, and it was much, much worse prior to Director Zarenda being there. And I think a lot of the visits that were getting canceled before have now gotten better as far as cancellations, but we also wanted some protection around cancellations and cancellation notifications. People shouldn't fly across country or fly from another country or even drive from Vegas and find a sign on the door that says your visit was canceled. And so this would do a couple of things. If the notification, that it would require notification on a public space, so either on the website, which right now doesn't happen, or through like a push text notification, like what's happens with, I keep saying snow days and then I forget, in Nevada we don't have zillions of snow days, but that those push notifications would go to anyone who is registered for that service. It would also require, if the notice was 72 hours or longer, then a deputy director would have to approve that so that people knew it wasn't just a random, like a visiting officer canceled visit today. And if it was under 72 hours, then the director would just have to approve it in order to make sure that administration was in support of that. In addition, the department would provide a quarterly report to include the number of cancellations per facility and the reasons for the cancellations to the Board of Prison Commissioners. So there's a reporting aspect also. The second part of the bill, the other half of it, is really about the creation of an ombudsman office. Those of you that were at interim judice, this was something that we really wanted, and unfortunately at the time was not an option because the administration that we had at the time was not willing to even have that discussion. The director would be, and I'm not sure if your copy says it might say the AG's office. That's because that's what was currently in statute, but we have since amended that to the director. The director of NDOC would establish an office of the ombudsman. It would be independent and impartial from Department of Corrections, and it would assist in strengthening procedures and practices that really lessen the possibility of actions occurring within the department that may adversely impact the health, safety, welfare, and rehabilitation of offenders. The next statement on it says that the director would make the funds available to support the Office of the Ombudsman. We are still working on that. We actually had a plan that is, I'm gonna let you talk about that when it comes up, that has shifted a little bit on that one. Basically, this ombudsman would be able to have access to Notice, which is the computer system that the prison uses, and run reports to look for patterns of problems. So if it is food issues, if it is correctional abuse, depending on what it is, that they would be able to see those patterns and then make recommendations to the state about how to address those. I got ahead of myself. They would also be, so there would be an RFP, and then the ombudsman, once that bid is accepted, would also provide training or refer training for officers and people who are manage the grievance responses to make sure that they're meeting all of those requirements. And then lastly, that access is they would be able to provide a report back on grievances, whether they were accepted or denied, were they meeting timelines, and various other things. And they would have the access to internal grievance audits.
Hello, James Renda for the record, Department of Correction Director. So we have gone over this quite a few times. Just so everybody know, I did meet with our Deputy Attorney General that represents corrections, and he concurred what I saw in Connecticut. Connecticut had the ombudsman when I was there, separate agency. It's not a state agency. It was just an RFP of any law firm that was willing and interested in taking the contract. It does reduce litigation cases in the future, and it does help everything to be more transparent about the agency, especially if we're an agency that's supposed to be transparent and not hiding anything. The cases that go to court are usually cases, the way grievances work and the way the agreements with the U.S. Supreme Court is the offender has to go through a process of grievances, the informal, step 1, step 2, step 3 ending at the director. If those steps have happened, it gives the inmate, and the inmate still doesn't get resolution, it gives the offender the ability to file litigation in court. What the ombudsman will do is will play almost like the mediator for the court, the arbiter for the cases. So that person can act, or a group can actually help prevent these cases from actually going further by being the outside entity that can actually determine whether or not the grievances were warranted, whether or not everything was done properly. The other piece that helps us in litigation with ombudsman is the training aspects, training and monitoring of the books. The ombudsman should, and which it did in Connecticut, had access to case notes. So anytime that somebody meets a caseworker, like what happens here, meets with an offender and they have a problem trying to resolve a issue or a complaint, the caseworker has to put a case note in the notice. Notice is available for tracking and also for the next step level grievance to go back to see what was actually done at that level. Was it already sent? Was it answered? Was the time frame met? Which would be an important piece for the ombudsman as well, to have access, if this went through, to have access to notice so they can actually monitor also the time frames and due processes, especially when you have due process related to discipline. We do have a significant number of court cases that are litigated against the department based upon due process failures, based on discipline. There is a specific due process for handling of discipline, the notice of the charges, the time frame for when a charge can be heard, the sanctions. There's actually a due process for that. If it's not followed, there it goes for litigation again. But that can also be something that the ombudsman should be able to monitor and focus on, so that everything is following the steps. And a lot of it is done by accident, but when you have an ombudsman following it, it actually can put things back in focus or change the direction of what happened in the grievance or discipline or the appeal, so that it does not get to a court litigation. Unfortunately, it's hard to determine cost savings on non-litigated cases because we don't know about them, and we will never know about them. We just could go back in time to say what was actually litigated and did it reduce those numbers over the next few years that it was a few years earlier. But I know it's significant. I know states that have done this do show reduction in litigated cases. Right now, we have 662 cases in litigation against the department currently today. Those can be reduced dramatically if we do something different. And doing something different is, to me, is the piece of the ombudsman to help out with making sure that things are done properly, even if they were missed. The other piece of this bill, when you're talking about visits, unfortunately, I'd say almost all, if not all, visits are canceled at the last minute. It's a 99% due because of staffing. When we have staff that don't show up for work or someone's calling out, we can't get people in on overtime because there is no more staff. There's a process that the facilities do with what they cancel or move around or reduce on staffing so that we can actually run the operation safely. Unfortunately, visits is one of those that probably gets shut down first or close to first. So it happens literally at the first of the shift. If you have a visit at the beginning of the shift, you're not going to know until you show up at the facility and they find out they didn't get enough staff in and they tell you then. We could still post and notify people, but I don't think it's going to really help with those that are traveling because they're still going to get there probably an hour before their visit begins, and that's when we find out that we don't have staff to run it. But we should have a process to notifying the public because there are chances of the afternoon visits, saving someone a trip from Las Vegas to Indian Springs could help, or even Phoenix up to Las Vegas. We still can do that and should do that notice to the public. And it's not just cancellations of visits. It should be cancellation of any operations and things should be notified on our website, or a process so people understand why or what happened for the day's events. The last piece that I can go over about the ombudsman as well. The ombudsman's office have the problem I could see that has already happened in 2011 legislation. The legislation was enacted the Attorney General's office to have the ability to scope for an ombudsman's office related to under the Attorney General to oversight of corrections. Unfortunately, it was never funded, never happened, but it is already currently in statute that there's an ombudsman available or scope that can go under the Attorney General's office currently. However, it still takes the avenue that there's a state agency overseeing another state agency, which to me, I think the purpose of this one would be to have a separate, complete entity, a private firm, whatever it is, that can actually have somewhat of an oversight. And it's not a legal oversight, it's just an oversight to be able to show in discrepancies, inconsistencies, or patterns of things that probably shouldn't happen that could be more effective for better corrections. But that's all I got on this, but I think it is purposeful. And I do believe it would help in our litigated cases. The only part of this I would have to look at is how we're going to get it funded. But I know we turn in a lot of money under Category 1 funding, which is our vacancies and our staffing. And that's enough to at least get this so that we could refocus or put the money into an IFC contingency to be able to pay for this, at least for the first contract year or 2 years or whatever the contract year is, to see what the benefit it will have and if it really will reduce litigation and cases and problems in the future, even tension. Thank you.
All right. Thank you very much. I'm sure we have more than a few questions, so I'll start with Senator Stone.
Thank you, Madam Chair. Thank you for the presentation. Director Zarenda, we've talked about staffing levels, and I think we've both kind of come to the conclusion that we don't pay our prison guards enough money, and as a result, we have like 400 vacancies, 1,500 slots, 1,100 vacancies. And you mentioned that 99% of these cancellations are going to happen at the last minute. I don't see how an ombudsman is going to mitigate that issue. And, you know, here we are spelling out in statute the visitation rules that I would assume that when this becomes law that you're going to educate your troops, if you will, on visitation rules, and people are going to hopefully follow those rules. And so I'm concerned at a time when we don't have enough money for corrections for hiring more prison guards. We're going to spend a lot of money on an ombudsman, which may make your job a little bit easier, but we put you in this position for a reason. We trust that you're going to bring the Department of Corrections into the new millennium, if you will, and make sure that our officers are safe, making sure that the prisoners are appropriately taken care of. Don't you think that might be more appropriate to pass this bill without the ombudsman to give you the opportunity to fix these problems? And then in 2025, if you come back to us and say that this expenditure of the ombudsman, which is probably going to be in the six figures or more, is proven to be needed. So I just wanted to get your opinion on that.
So James Render, for the record, actually I was thinking the opposite. When you talk about visiting policies and procedures, there's already a policy and procedure oversight, which is the Board of Prisons Commission, which is built into the Nevada statute already in the Constitution, Nevada Constitution. And there's also possible with bills that are being passed today that the visitation is actually going to fall under 233B process of public hearing. So there is going to be oversight of that. So I was thinking more of the opposite. You have an ombudsman that will help make sure that things are being focused and in compliance of even things that are accidental, and then the other piece will already be under public hearings. Just a thought.
Thank you.
Other questions from members? Senator Orenshaw.
Thank you very much, Chair, and thank you, Ms. Hawking and Assemblywoman, Director. I'm just wondering if this passes and we have an ombudsman and maybe some problems are able to be solved before it gets to the point of litigation, do you think that there might be, I guess, some savings for the department and in terms of not having to end up in state court or federal court on some of these issues if the ombudsman can try to maybe cut through the red tape and solve some of the issues that come up?
James Render, for the record, I know it will, but it's hard to prove because you're not going to see cases come up. The thing what you can prove is that it'll be quicker resolutions. When you're talking about court cases, they could be 2, 3, 4, 6 years even late down the road, which builds up tensions with the offenders. When they really have issues that they believe should have been resolved that aren't, that's where you can have an ombudsman can actually help resolve issues, or at least explain and make the offender feel like they got someone outside the agency to listen to them and give a regular layman term definition of why the grievances didn't go through, rather than waiting for a court case, which could take 2 to 6 years before it gets there with the tension and all that.
Thank you, Director. Thank you, Chair.
Other questions? All right. I don't see any other questions, so thank you so much for your presentation. We will move now into testimony in support of AB 452, starting with those in person. Are you guys, yeah, well, we'll start in Las Vegas. Go ahead with your support testimony in person in Las Vegas on AB 452.
Good afternoon. My name is Pamela Browning, Pamela Browning. I have an incarcerated loved one, and I also am a core volunteer with Return Strong. As I was thinking about what to write, I was thinking about our letters and how many come in the topics that are covered and how little we can actually do to resolve the problems that are shared with us. Then I started thinking about how instrumental an ombudsman would be if they had access to notice, the note system, and could run a report and look at the patterns of problems across the facilities. So I decided to look at a few areas. First, we have 175 topics that have been brought to us through our letters. In the last 5 months, we have received 212 letters about the food quality and quantity, 184 letters with complaints of correctional abuse, 559 letters regarding medical, dental, and mental health neglect, 270 letters that had to do with violations of due process and grievances, including 130 grievances, 221 letters about lockdowns, isolation, and lack of time out of cells, 263 facility complaints, heat, hot water, AC aren't working, no cleaning supplies. This is a lot of concerns and issues that an ombudsman could help us follow up. We need this in Nevada, and I am in support of AB 452. Thank you.
Good afternoon. Thank you, Chair Schreiber and the committee for the hearing of AB 452. Which is such an important bill. My name is Melissa Duna, Melissaduna, and my son is incarcerated at High Desert State Prison. I want to start by explaining this. My son isn't a hardened criminal. He was addicted to drugs and stole. What happened to him inside High Desert Prison was horrific. Our ability to get help had been almost as bad as the situation. My son moved to protective custody. After being assaulted, who was a known predator, we fought for anyone to listen to us. We looked at things that happened to him in prison. He was poisoned. He began having health issues. His mental stability was all off the wall. And then I found Return Strong. And I knew we weren't alone. I came across other sons, daughters, and family members that were going through the same thing. The torture and abuse is always not from just inmates, it's from workers also. Where do you go for help? The Attorney General's office? Well, they represent NDOC. The Inspector General? They're impartial. They're the investigators also for NDOC. Wardens? They don't answer. It's horrible. And this is the way it's designed to work. We need an oversight. We need a neutral party. We need to be impartial and advise a path to the resolution beyond waiting years for lawsuits to happen. This is why I support AB 452. And it's time that everybody else in Nevada does too, with the amendments of the ombudsman. And let me note one other thing. I was at visitation last week, and there's all signs about how to protect everybody who works at NDOC. But who protects the inmates? Thank you for listening to me.
Good afternoon. My name is Ashley Gaddis, ASHLEYGADDIS. I have been formerly incarcerated at Florence McClure Women's Correctional Facility, and I have also been staffed with Return Strong. I'm here today to give you a little personal insight as to why this bill is important. I'd like to say that there is and continues to be a large number of offenders whose frustration and anxiety stay on the rise because of the lack of resources available in seeking relief and resolutions to complaints about conditions of confinement and other violations. Since working with Return Strong, I have read countless letters from the incarcerated of pure desperation and despair. These complaints range from the lack of food, outrageous pricing in store items, visitation, abuse, and assaults. Most of these complaints have been exhausted using the grievance process and remain unresolved, with the initial complaint still being problematic and progressive. Now, there is a chain of command that must be followed when seeking relief and resolution, or even sometimes it's just a question of explanation that we're looking for. The chain of command would depend on the nature of question or complaint, and most can be resolved on the lower level through the caseworker, but they aren't. Instead, there is no response or unprofessional comments like, "That's not in my pay grade or job description." And this is what fuels the fire and results in costly litigations, mental breakdowns, suicides, hostility, aggression, and even hunger strikes. It does not have to be this way. I have my own personal experience at Florence McClure that involved a male officer who had recently been transferred from the men's prison. His behavior was anything except professional. In best words, I would describe him as a bully. The issue started as a disagreement over cleaning supplies. It resulted in this CO continuously coming into the unit, yelling, hovering over me with threats, harassment, and unnecessary cell searches. It got so bad that I would refuse to come out of my room while he was working in fear of what next. I reached out to mental health, who told me there was nothing that could be done because there was no suicidal or homicidal thoughts. It shouldn't have to take a person to be thinking suicidal or homicidal when reporting an officer's behavior and the effects that it's having on them, me. I also expressed the triggering of past trauma, and there was nothing that could be done. I spoke with my caseworker, I had side conversations with lieutenants, and all they did was defend him. In this situation, I was scared to initiate a grievance due to the possibilities of retaliation, which clearly was already happening. Eventually, my family called Shift Command with concern. I was called to Shift Command and questioned about the problem and told them I didn't feel safe. They continued to defend him. The harassment went on for about 3 months, and I was transferred to camp outside of the facility. Having complaints and concerns circulated internally is not working. Having an ombudsman is greatly needed. I feel that with an ombudsman, there will be actual and factual resolutions to the complaints and concerns that go unnoticed, reducing the levels of frustration and tension among the population. Having an ombudsman would also give oversight to the grievance process, which is greatly needed. So I'm here today to support AB 452 as amended. Thank you.
Yes, I am John Luke. I am a formerly incarcerated prisoner from High Desert State Prison. I am talking in support of this ombudsman, an outside objective witness with a golden key authority, also known as an ombudsman, would be a wise expense, someone who physically can go in and observe the workings and directly and passively through the camera system. This person would be able to observe up to 2 weeks into the past through his method. This outside person would be able to see the living conditions and question why are things the way they are. For example, when on the weekends, when it is apparently not enough staff for normal operations, nobody is allowed out of their cells, but there's enough staff to allow 24 inmates in every unit out of their cells, but just nobody else. if there's enough staff for that number in the morning and night, why can't anybody else come out all day long? The COs are paid to watch inmates, correct? They also could observe firsthand the cleanliness of tiers and eating areas and showers and water temperature and AC. Nobody bothers to check these things. Also, medical facilities, the cleanliness in that area is abysmal, as well as the operations of the extra secure yards that have been erected and shrank the normal size of the yards but are never used anymore. The camera system without no real or they can also use the camera system to passively observe anybody, would lead to a lot of accountability on how the interactions are taking place and whether or not with all of inmates or just certain special inmates at the expense of all others. To have someone to see the internal logs and emails and actually see if the orders and directives are followed and conducted could yield some clarity about what's going on behind closed doors. An ombudsman could then report directly to outside agencies about what exactly was found through their observations. This would allow a lot of accountability to staff members of the facility of how professional they are performing their duties. Are they being fair, firm, and equal to all inmates or just some? Why has the grievance process been as laid out in the ARs become so complex, even the most savvy inmate has hard time navigating such basic issues and bringing up just simple problems? Question why this is and observe how up to date these regulations are and whether the equipment works and is being used correctly in the law library. The last time I was up there, the regulations were so far out of date, they're not even relevant anymore, and there's nothing even being followed that's on paper. Investigating broad claims of misconduct and abandonment of duties by said ombudsman may be exposed internal communications and cover-ups or lack of any communications. Since 2020, there has been several times where internal memos are only spoke about and never printed. To prevent litigation and lawsuits, the ability to interview COs and inmates alike on incidents of beatings and murders, as well as other incidental situations, being able to observe food service in units as well as culinary, both before and after chow, would be invaluable, with wardens reducing calorie counts from 2,800 calories to 2,200 calories. Every ounce of food matters. And that goes on those trays are necessary, making sure that all inmates involved are dressed for food service and dishing appropriate portions. They also would be able to verify the amounts of food being sent from the kitchen. They would also be able to verify the staffing and where they are posted. Far too often, the guards are posted in places out of the way so they don't have to do anything. For example, when visiting is not run, there are up to 4 guards just hanging out up there all day long. Or during lockdowns during the week, one can see guards just standing in medical, law library, and chapel just standing. An ombudsman would have the ability to randomly interview inmates about problems within the facility and yield valuable insights. Problems with staff that go unnoticed or completely unchecked, night shift supervisors that don't or won't do their rounds, as well as retaliatory events that COs do indirectly seek revenge on inmates using other inmates as leverage as the price of their privilege, extorting them to get info or contraband. Observation needs to be assessed about whom gets appointed to these inmate advisory committees. More often than not, all porters who get all the benefits no matter what are the ones that get appointed to these positions. So it doesn't matter to them if they're given or denied any privileges because they get them anyway. All the inmates that are denied privileges are locked in their cells and they don't get any voice on these committees. So speaking, I am for this bill, AB 452, as amended. Thank you.
Good afternoon. My name is Sonia Williams, SonyAWilliams. Many of you have heard me testify about pieces of my family's story. My daughter's father was diagnosed with multiple cancers while he was incarcerated at High Desert State Prison. I want to share some piece of the story that you might not know. And I wish at the time we had some type of protection, because when it was us versus the machine of NDOC, we never won. Over the past 2 years, I have given public comments on multiple issues, both from my own experience with NDOC and as a core volunteer with Return Strong. I help read and process letters we receive, which could have been addressed, maybe even resolved, if we had a neutral party to review and make recommendations for resolution. Most issues cannot be told in 2 minutes or less. AB 452 could have helped me resolve the situation that occurred in the summer of 2021 when I took my then 6-year-old daughter, Jacelyn, to visit her terminally ill father. At the time, the visiting rules stated that if children were uncontrollable, a visit could be canceled. We had a special visit with Eric, who was wheelchair bound because he was so weak, and then shackled at hands and feet to the wheelchair. Jacelyn had not seen her father in 2 years due to COVID. Anyone who knows Jacelyn will tell you that she's the most loving, affectionate, sweet, natured child in the world. As I was signing us in, she ran and hugged her dad and was immediately physically pulled off of him, and they ended our visit. At the time, Jacelyn was like 35 pounds. She never saw her father again because, again, they suspended our visits. They gave him a write-up for unlawful contact, and he died 6 months later. What's even worse is he could not even hug Jacelyn back. That is the last memory Jacelyn has of seeing her father. If there was a neutral third party, we could have filed a complaint, and there is a possibility that Jace would have seen her father again. There would have been an opportunity for resolution, but right now, NDOC holds all the power. Right or wrong, whether we get the truth or a fabrication of the story, they own the narrative. This is just one example, but we have families who can't be here today that were unable to visit a loved one in the ICU due to COVID, who had hours to live, families who have flown in from all over the United States and the world to get off a plane and find out that the visits were canceled, families that saved to make one visit every 4 or 5 years and show up and see a sign on the door that's saying that the visits were canceled due to shortage of staff. We understand that this won't fix everything, but it will create a process that provides at least enough protection that families and children are not victims with no recourse. While what happened to us was horrible, what was worse was never having a voice. I am in support of AB 452 with the amendments. We desperately need this. I never want another child to deal with the trauma that Jacelyn has had to endure at the hands of NDOC.
Hi, my name is Chris Covello, Kovello. I am here regarding AB 452 and the amendments. My son was previously incarcerated at NDOC. He is home now and doing very well, thankfully. Although I have no idea what happens to people without a family to help them, but that's a story for another day. But I've done a lot of help for my son. Today I'm here in support of AB 452 and the amendments. I'm going to share two things. Both are about food or lack of food that I really believe an ombudsman could really help in this situation. When my son was in prison, he went to work at one of the NDF fire camps. You have to understand that the camps are far from everything, and he was a POH. While he was there, he was training and working for NDF. While they're there, they're supposed to get additional calories due to their nutritional needs. I remember him calling one night and us speaking on the phone, and I asked him, as I did almost every time he called, well, what'd you get for dinner tonight? Because it's kind of hard to know what to talk to them about. And he said that dinner tonight was a piece of fish that was equal to about 2 fish sticks, a 1/4 cup of rice, and a little bit of dry salad. So then he talked to me about the constant hunger pains that never go away. So then a few days later, there was an incident at the camp where people got write-ups and they were accused of stealing food because they went and they got seconds. But apparently, no matter what, if food is left over, it's thrown out. Rather than give hungry people food that it's been paid for and it's sitting there. I was infuriated when I found this out. Then I found out that it isn't just at camp. The same thing happens everywhere. Every facility, and I'm also an advocate with Return Strong, we have letters from individuals about food being thrown away and people being hungry. So I was very desperate. I was desperate to find out what could we do about it. So I needed somebody to listen to me, to help us. I went to NDF and I spoke to them to find out what's going on. And then, because I'm a season ticket holder with the Las Vegas Aces, and I knew that Governor Sisolak was at many of the games, I went with signs and letters from different people who had family that was incarcerated at NDOC. And I would try to get close to him, and he had his entourage with him. I almost got myself arrested at one of those games. I know it was crazy, but I was desperate because no one at NDOC cared at all. So every week with Return Strong, we get letters talking about how hungry they are. There have been a million explanations from NDOC, and maybe some are true, but we need is someone who can look at these complaints, investigate, make recommendations for solutions. We want more than just our voices heard. We want to see our loved ones fed appropriately. We want somebody to be able to investigate what he said and what she said, that type of thing, and get to the truth, and let's find remedies for this. I am in support of AB 452 with the amendments, and not just because of the food, but because we desperately need oversight. Thank you very much.
All right, it looks like all of our support testimony in Las Vegas. So we'll come up to Carson City now for in-person support testimony on AB 452.
Good afternoon. Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We want to echo the previous comments made. We do support this bill, the bill, and we support the amendment with the exception of C, the Office of the Ombudsman may not review any grievances relating to offenders' underlying criminal conviction. And the reason I say this is because going back to 2007, during the Advisory Commission on the Administration of Justice, several members, advocates, myself, and a few others, Flo Jones, Teresa Werner, Michelle Ravel, Pat Hines, and some others, we worked on getting an independent oversight committee over NDOC. Ultimately, in 2011, Senate Bill 201 passed, but that became the Ombudsman bill under the control of the Attorney General's office, and it wasn't funded. That happened in 2011, and guess what else? There was something else that happened in 2011 that the NDOC hid for many, many years, and that was NOTICE, the Nevada Offender Tracking Information System. When it was installed in June of 2007, it flipped, and it put false felony charges in inmates' files. Inmates are still having false felony charges in their files, and we're talking murder, sexual assault, burglary, crimes they never committed, or the crimes that they have committed had doubled, unbeknownst to the parole board and to the pardons board. And so we have submitted our amendment, and we would like to substitute our amendment for Section C, have that removed and ours placed in, which would show the Ombudsman's position will include looking at the offender's Nevada Offender Tracking System notice, file to review any discrepancies in which the offender claims are inaccurate and that no disciplinary action should exist. The Ombudsman will review the file and determine if the disciplinary action had been properly grieved and then litigated in court, and the offender had won the litigation, and the disciplinary action must be removed. The Ombudsman must inform the Nevada Board of Parole Commissioners and the offender of the removal of the disciplinary action from the offender's notice file. The Ombudsman must inform the Nevada Board of Pardons Commissioner and the offender of the removal of the disciplinary action from the offender's notice file. The Ombudsman's position will include investigating any allegation of an offender has false felony charges contained within their Nevada Offender Tracking System notice, that file that may have been a result of a 2007 computer glitch. The Ombudsman's position is to review the notice file when the offender claims that the file contains inaccurate information that pertains to his or her sentencing structure in which it appears another felony crime had been added. The ombudsman must review the district court file to confirm that if this allegation of a crime actually occurred. If it has not, the notice file must reflect the removal of the false felony charge. The ombudsman must also review the district court file and compare the new allegation of a felony crime to a past conviction in which the offender had been incarcerated for either expired his or her sentence or was paroled. If the ombudsman finds that a new felony charge in the notice file is not a new crime but an old prior conviction, it must be removed from the notice file. The ombudsman must notify the Nevada Board of Parole Commissioners and the offender of the removal of the false felony charge in the notice file, and the ombudsman must notify the Nevada Board of Pardons Commissioner and the offender of the removal of the false felony charges. And I will tell you that something recently happened last week based on a false felony charge going back. After this had happened, many years ago, I was contacted by several inmates, one particular. He was claiming that he had a false sexual assault charge and other things in his file. And he had heard about the computer glitch. And I told him, I says, well, file your grievances and dues. You may have to take it to court. And anyways, ultimately, he wound up going to a parole hearing in 2013 and 2016. And unbeknownst to him, all these false charges were submitted to the parole board and he was denied. He filed a writ of mandamus in the 8th Judicial District Court. And then last week, the Supreme Court came out with an order on that. And I think I may have Miss Anne Marie Grant on the phone who will be calling in and she'll touch on that. So we ask that you on behalf of Nevada Strong, Battleborn, and advocates for the inmates, we ask that you take our amendment and remove section C under Return Strong's creation of an ombudsman and replace it there. Thank you.
Oh, Ms. Brown, I think we have a question for you. Senator Krasner, go ahead.
Thank you, Chair. Since you're proposing an amendment, you just mentioned false felony charges placed in inmates' files. How are you alleging that those false felony charges got into the inmates' files?
Tanya Brown, for the record. I am not alleging they are false felony charges. I am stating a fact. And the fact is, it was during the 2011 sworn deposition of the Assistant Director, Don Helling, when we obtained the offender information summary contained some false charges in there. And it made it appear as though the inmate had he had been in for many years and that he had got a new charge because it was a 2007 charge on it. And so we asked the director about that charge and what he stated, and I did let Director Zarinder read the deposition on that part a few moments ago. What he stated was that when notice was installed, it flipped and somehow caused errors that put false charges in their files. That's how we found out about it. And this was in 2011, and this happened in 2007. Now people, and I know that the inmate that I am referring to, where that there was a false burglary charge in that file. That information was then submitted to the parole board, and he had been denied. That false information was also submitted to the pardons board. And then again, the story started to break, and then other inmates who were in prison and had sexual assault charges in their files, and they weren't in prison for sexual assault. The one I just recently spoke about, came out last week, he, like I said, he contacted me many years ago, and he had additional sexual assault charges in his files. It was a huge thing back in the day. And Assemblyman Al Kramer has come to me during his last term because he was getting information from inmates out of Ely about false charges, and he had no idea about this computer glitch. He knew that I did. But it's still happening. And again, the Supreme Court just kind of rendered a decision last week, I think it was the 11th of May, and it dealt with the 2016 parole hearing in which there was some false information in there. And there's not much they can do, the Supreme Court, because they can't, you can't go back and get the parole hearing. He lost all those years. He was a low risk. They made him a high risk. He could have gotten out. And this is what could be happening. And what else is happening that has come up with this information from other inmates that I am aware of is that the inmates, the NDOC staff will remove that false felony charge. okay? And then what happens is it'll go to the parole board, and sometimes it'll be removed, and then it'll reappear, and then it'll go to the parole board after the caseworker had already removed it. These were some of the issues. So this is why, the way I have this, it puts the parole board and the pardons board on notice that there is an issue. And I will tell you, there was hearings held on this back in 2011. NDOC staff were fired, and they said that they did not know how to fix it. Well, as far as I know, it still exists because they have not been able to fix it. I hope that answers your question. Thank you.
All right. And we're also going to need you to follow up with documentation on all of that, a copy of the deposition, a copy of the reports that were provided to the parole board, a copy of the judgments of conviction to, substantiate the explanation that you gave.
Thank you, Madam Chair. Can I say that it is a public record? The Assembly, I believe the ACAJ has it, the Nevada Board of Prison Commissioners has it. But yes, and I will provide you with Don Helling's deposition that I had shown, and it clearly shows that.
All right, thank you.
Areli Rodriguez for the record. ARELI RODRIGUEZ. I am here to talk about Spanish-speaking only people and their inability to access anything in their own language. Visitation policy, dress code requests are all in English. The signs on the doors are in English. The kites to request medical care are in English, and there is nowhere to go to get help. Visitation applications are in English only. If there is an ombudsman, those issues, they could review that across the state and see how badly people are impacted, and there is nowhere to go. If an ombudsman took that issue, they could make recommendations to the state to make sure people have access to information. And this is why I am in support of AB 452, and I'm here with Return Strong. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, SHEPACK. I am the State Deputy Director of the Fines and Fees Justice Center. We are here in support of this piece of legislation today. For far too long in the state of Nevada, we have either fixed problems in the Nevada Department of Corrections through litigation, or every other year coming to this body and bringing you a litany of bills to try to address these issues. We believe, as we've seen in many other states, that an ombudsman can address many of these issues. Not only will it reduce litigation and likely save the state money, it'll reduce legislation, as many of these issues will get addressed. It's a best practice everywhere that it's implemented. It will directly impact the work of our organization that looks at some of these financial issues, as those issues can be driven directly to the ombudsman, as well as many of the other issues that we've brought before you this session and in previous sessions. For those reasons, we are in strong support of this bill. And lastly, I'll say we need to be a yes and state. Are we paying our public employees enough and our correctional officers? Clearly not. We have a staffing problem. But just because we have one issue doesn't mean we need to maintain the other issues. We should implement best practices, and we should also ensure that we are providing the best pay and resources in order to staff our prisons so that we can also eliminate issues on that area. We are here in support of all of those things. Thank you.
Good afternoon. My name is Nicole Williams, WILLIAMS. I have a loved one who's in prison, and I am also the mail coordinator for Return Strong. I see, touch, screen every single letter we receive. First, I want to thank you for hearing this bill because it is so urgent for all of us who are impacted by incarceration. I'd like to talk to you about the protections AB 452 will provide for visitation. My husband is incarcerated down south, and I live in northern Nevada with our 3-year-old. You know what I want you to know is she loves her daddy. No matter where he is, she loves him and she needs him. The time we spend in the visiting room lets her bond with him, lets him learn and remember how to interact with her. They create memories that are the foundation for the relationship now and 20 years from now. Unfortunately, we aren't able to make that trip often, but we do make it. I've always wished that we had video visits, and hopefully those will come with tablets, but I would hate to see any family lose the ability to look in their loved one's eyes, touch, hug, hear, laugh, and just be in each other's presence, because just like you love your families, we love ours. One of the most powerful things this bill does is protect our ability to have in-person visitation, even as tablets and video visits and technology become a method to add to our interaction with our loved ones. It should never replace the ability to be in each other's presence. My husband will be home soon, and I pray that he will stay home and we won't be in this situation again, but I'm here today to make sure that all families in Nevada always have the legally protected ability to sit with their loved ones like my daughter and I do now. I am in support of AB 452 with the amendment. Thank you.
Thank you all for your testimony. I think that brings us to the conclusion of support testimony in person, so we will go to the phones for support testimony on AB 452.
Thank you, Chair. If you'd like to testify in support for AB 452, please press star 9 to take your place in the queue.
Good afternoon. My name is Deshaun Jackson, D-A-S-H-U-N, J-A-C-K-S-O-N. I serve as the Safety and Welfare Policy Director with the Children's Advocacy Alliance. And the Children's Advocacy Alliance stands in support of AB 452. We believe when we consider family preservation and connections, it's important that youth have that time and families have that time to spend with their loved ones that are behind bars, whether that be via a tablet or in person. It protects those. And so we definitely stand in support of family preservation and family connections. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Amber Falgo, A-M-B-E-R-F-A-L-G-O-U-T, and I am the Northern Nevada Manager with Battleborn Progress. We are in strong support of Assembly Bill 452 as written, but really we want to highlight the addition of a state corrections ombudsman to provide oversight. Having oversight from someone outside the department to investigate grievances, complaints, or any other issue is desperately needed. Session after session, we hear about what incarcerated folks and their families deal with and a system that is not set up to deal with those issues. Adding an outside source that will help advocate for inmates and their concerns is a step in the right direction. This ombudsman would bring much needed relief and transparency. Please support Assembly Bill 452, and thank you for your time.
Hello, my name is Betty Guess, B-E-T-T-Y-G-U-E-S-S, and I have a loved one incarcerated at NDOC. I'm here in support of AB 452 today. I would just reiterate everything that everyone else has already said regarding especially the grievance process and the need for an ombudsman to oversee that. My loved one has experienced all of the things that you've already heard regarding food and lack of quality and lack of quantity. He has experienced problems with the grievance process regarding medical care and so many other things that you have already heard about today. Also on visitation, I don't live in Nevada anymore. I'm 1,800 miles away in Indiana. My son has been there for 13 years now and has had one visit, which was from me last month, and that was only due to the benevolence and kindness of Return Strong members. I am a core volunteer with Return Strong and the chaplain for that organization, and I strongly support AB 452, and I thank you for hearing this bill today, and I urge you to pass this bill. Thank you.
Anne-Marie Grant, advocate for the inmates and the innocent, ANNEMARIE. We are in support of the bill and we support Return Strong's amendment. However, we would like the ombudsman section to include our conceptual amendment because inmates are still being affected by the computer glitch that Ms. Brown spoke of. And I'd just like to echo her other statements and reference Nevada Supreme Court case number 84892, where it actually mentions the computer glitch and the false felony charges. Thank you.
Hi, my name is Caitlin Ahern, KATELYN AHERN, and I have a loved one incarcerated in Nevada, and I'm in support of AB 452. Thank you.
That concludes all callers in support.
All right, we'll move to testimony in opposition to AB 452. Anybody wishing to give in-person testimony is invited to do so now, but I don't see anybody coming forward in either Carson City or Las Vegas, so we'll go to the phones for opposition testimony on AB 452.
If you'd like to testify in opposition to AB 452, please press star 9 now to take your place in the We have no callers in the queue to testify for opposition at this time.
All right, we will go to neutral testimony on AB 452. Not seeing anybody coming forward to give in-person neutral testimony, we'll go to the phones for neutral testimony on AB 452.
If you would like to testify in neutral for AB 452, please press star 9 now to take your place in the
Hello, legislative team. My name is Leslie Quinn, and I'm calling in neutral on AB 452. I believe having the ombudsman connection would definitely help in the processing of the inmates' issues and/or incorrect inmate charges. In fact, my husband, who works for NDOC, is willing to be a liaison between NDOC and the ombudsman's office if NDOC will approve him. However, I am in opposition to the recommended visitation as written, specifically in regards to a 72-hour notice being given to cancellation of visits if the facility has to shut down in an emergency. Also in regards to hospital visitation, as this will create a safety and security breach for not only the correctional officers, but other inmates, visitors, and the public in general. So again, my name is Leslie Quinn. I'm in neutral on AB 452. Thank you for hearing my testimony.
That concludes all callers to testify in neutral at this time.
All right, then that brings us to the conclusion of testimony. Do the presenters have any closing remarks on AB 452? All right, then. I will close the hearing on AB 452. Thank you, everybody, for an engaging day with lots of testimony and for answering all of our questions. We have one item left on our agenda, which is public comment. Anybody wishing to give public comment in person is invited up to the front now, but I don't see anybody, so we'll go to the phones for public comment. Each person will have 2 minutes to give their public comment.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Caller with the last three digits of 266. Can you please press *6?
Yes, my name is Leslie Quinn, and my public comment is I am so grateful that you have so many people that want to support people just in general and their freedoms. And my hope is that the same concern would be given to staff that works for any of public, whether it's police officers, correctional officers, hospitals, nurses. Please also consider them and just having that respect for them as well. And I thank the legislators that they are doing that. Thank you. I appreciate it.
That concludes all callers providing public comment at this time.
All right, and that brings us to the conclusion of our meeting. We are meeting again tomorrow. We're still working on the schedule to see if we might be able to get started a little bit earlier, around noon or 12:30, but there are a lot of moving parts, so stay tuned. But we will be meeting tomorrow either way for both bill hearings and work session, and until then, we are adjourned.